There we go. I have clicked all the buttons. I think I'm live. Okay. Hey, everybody. We are back. Um, I am Carol Williams with Williams Immigration. As you all know, I run a boutique immigration law firm and I work with clients and people all over the United States. So I work with people in 50 states. I also work with people internationally. And I work with companies and families looking to navigate our U.S. immigration system. And so I've come live this evening, wanting to give y'all some information, but also wanting to answer any questions that you may have. I see some people are coming in, so that's a good thing. I hope everyone's having a good Tuesday night and had a good Labor Day weekend. I hope everybody got some time to just kind of relax and woosah for a bit. So one of the things I wanted to let y'all know is for family-based cases, the Immigration Service has said fairly recently in the past couple of weeks that they don't have to, and they will now not always issue a request for further evidence if there are documents that are missing. And these are kind of like, from my understanding, like your basic documents, right? So if you don't submit your passport, if you don't, your passport biographic page, if you don't submit your birth certificate, if you don't submit just the basic documents, like if it is a spousal green card case, right? If you don't put in your marriage certificate, immigration has said we're not obligated to ask you for that, right? And usually they would send you a request for further evidence and say, hey, we need these documents. Now they're essentially saying that we don't actually have to ask you for that, and we can and will just simply hit the denial notice, and spit out that denial notice for you. Dawson, you're more than welcome to put your question in the comments, and I will see if I can get to it. So keep that in mind. Like, seriously, y'all, keep that in mind. A lot of folks are trying to DIY their immigration right now. And now it's just kind of not the time to do that. It is not the time to do that. It is hard. These immigration streets these days. Immigration is complex. What I think some people don't understand about the immigration forms is they think that they're just a bunch of questions and it's really easy to answer the questions. You fill in the answers. Some of them, if you're applying for adjustment of status, which is the last application for your green card in the States, I think the last 3 to 4 pages of that form, it's just a bunch of yes, no questions, right? But what you should know about those questions is that each question is tied to a section of the law. And each section of the law is a section that says you are not eligible for a green card. So if any of those questions are yes, there needs to be an explanation because you've essentially checked a box that says I'm actually not eligible for this green card that I'm applying for. So immigration is really, really tricky. So it is a lot more than filling out forms. So just keep that in mind. I've got some questions that are starting to roll in, so I'm going to start looking at them. But we are live on Instagram, Facebook, YouTube, and TikTok. So hi to everyone out there who is spending a little bit of their Tuesday evening with us. So let me see what questions we have. And in between some questions, I'm going to give a few more updates or a few just kind of key things to really remember. Someone's asking, Noah, is SIJ's process after juvenile court approval, how long is it going to take for the process? I don't know. My office doesn't handle, and we generally don't do SIJ cases. So I would recommend that you have a conversation with an attorney's office that does SIJ cases all day, every day. not someone that dabbles, but someone that does them all day, every day, and they can get that info to you. Someone is saying, my friend checked her USCIS portal and the section for interview says completed. Is this normal? If the interview has been completed, it is normal. I'm in the military as a green card holder. Kyle, I hope I'm pronouncing that correctly. I'm in the U.S. I'm in the U.S. military as a green card holder. My mom applied for citizenship in December. And I can't see the rest of your question. So hopefully your mom gets her green card. I just can't see the rest of your question. And let's see here. What else do we have? Let's see here. I recently joined the U.S. Army. I came on a tourist visa, applied asylum, marriage to a citizen now. I don't understand your question. Recently joined U.S. Army. I don't understand your question. I'm sorry. If you could rephrase that, I can take a look back at it. Let's see here. Someone is asking, I'm curious what made you leave and get into consulting. If you're talking about leave the immigration service and get into consulting, I think that's what you mean. I am a licensed attorney, so I'm not just consulting. That's a huge difference between myself and some other folks out there. And there are lots of really awesome qualified immigration attorneys out there who've been to law school. And I wanted a different atmosphere. That's all. I just wanted to own my own firm. So, there's no massive drama that had me leave the government. F1 as a Canadian, so you're an international student who is Canadian. What is the timeline for I-130 and green card? It depends on what category you're in. Can I file concurrently adjustment of status as a spouse of an LPR? You can file concurrently as a spouse of an LPR if your priority date is current. So if your priority date is current. So what does that mean? So let me look up I usually don't sort of look things up at while I'm on live, but today feeling a little some kind of way. So if we look at the visa bulletin, there are categories for green cards. So if you are the spouse of a permanent resident, that makes you an F2. So it's really all about whether or not your priority date is current. The priority date is going to be the date that you filed the I-130. So you'd have to look at the priority date to see if your priority date is current. But in general, as long as I've been doing this, the only folks that I know I can always file concurrently, which means filing your I-130 and your 45 together, are immediate relatives. And so immediate relatives are spouses, dependent children who are children that are under 21 and unmarried, and parents of U.S. citizens. Those are the folks that you can always file those applications concurrently. If you are anybody else filing a marriage-based green card, you need to look at the visa bulletin and see what the visa bulletin says. But in general, no, I don't see that can be filed concurrently. And those are applications that my office helps with, helps families, stay together, helps U.S. citizens file to get green cards for their spouses. Let's see here. Will the embassy issue? This is a really good question, and one of the things I wanted to cover. So we're going to dive into this question. The question is, will the embassy issue a K-1 visa for a country that is under the ban? The answer is yes, they can, they should. There's a federal court case last week. I think I talked about it, maybe week before last. Sorry, getting comfortable in my chair here. So the travel ban is whether or not someone can be admitted into the US. So that means, will Customs and Border Protection, who are the folks that you see when you're in the airport, admit them? So that answer is pretty clear. If they're from a country that is on the complete travel ban, the answer is no. Customs and Border Protection will not admit them. They're not allowed to. But honestly, if you are from a travel ban country, even before you get to the U.S. airport, the airline is not going to let you on the plane, right? Like they're not going to do it. But the consulate can issue and approve a visa. They can approve a visa and then put the visa in your passport, because the ban is about being able to travel, and the ban's about being able to enter the US. The ban is not about being able to get a visa. So if you get your visa today, you're on the ban list. But next week, you're not on the ban list. You can take the visa that you got today and travel next week once your country is off that list. So the thing you have to remember about immigration in general is that the immigration process touches several government agencies. So so for some of my cases, we deal with Department of Labor. And this is all in one case. I can deal with Department of Labor, USCIS, which everyone sort of affectionately refers to as immigration, and then I can deal with the Department of State. And under Department of State's umbrella, that can be National Visa Center and or the consulate. If it's like a family-based marriage green card case, we can deal with USCIS, again, immigration in the States, and then the Department of State, who oversees NVC and the consulates. And then for both employment and family, we can also deal with Customs and Border Protection, because those are the folks that we see when we come into the country at the airport. So there's several different agencies that impact cases. And that's a case that's smooth sailing, no issues, no problems. So it is not unusual to have this sort of tension between one agency to the next, and you're not quite sure which agency is dealing with which part of your case. So that's something that I often explain to my clients. But they are able to issue visas, even if your country is listed on the travel ban list, but you may not be able to enter the US using that visa. So you're not going to be able to enter until your country comes off the travel ban list. So if you want to apply for the visa, you can, maybe in the hopes that your country comes off the list. And that's not just for K-1 visas. That's for any visa. That's for HSLs. That's for anything. What are all the medical records required to submit? So there is a medical form that you get when some of my clients take the form, they print it off, they take it with them to the civil surgeon. Others of them rely on the civil surgeon to have it. Doesn't really matter how you do it. And then the civil surgeon completes the forms, completes that particular form. If the civil surgeon needs more information, they will tell you that they need more information, or if they need you to have additional testing done, they will let you know that as well. And what other any advice for a green card interview? Be honest, be early, be honest. those are my two biggest things. My office does green card prep. We do mock interviews for people, for our clients. We will also do mock interviews for folks for an application that we didn't submit, to make sure that people feel comfortable with the process, so that when they walk in, they know, they have a sense of what's going to happen, the types of questions that they're going to get. But I always tell my clients to be early and to be honest during their interviews. And what else do we have? We've got if you have this is over from YouTube. If you have a deportable crime and USCIS approves your 601 waiver in conjunction with adjustment application approved, can DHS try to remove you because of the waived crime? Crime is not an aggravated felony. Crime not aggravated felony, waiver granted. I'm not 100% sure I understand your question. You have a deportable crime and USCIS approves. I'm not sure I understand your question, but here's what I'm going to say about adjustment of status, green card applications, and having a criminal history. The Immigration Service is definitely going to look at any sort of criminal history that you have. They are going to do biometrics, which means you're going to take a picture, they're going to take your fingerprints, and then they're going to run background checks. They're going to run background checks in the US and worldwide. So one, it's very important that you are honest in your application. I always tell people sometimes it is not the particular crime that was committed or the working without authorization or what have you. It is the lie about the thing that sends an immigration officer over the edge, right? So if you have a criminal background, no matter when or where it happened, I would recommend that you consult with an attorney and have them help you. The other thing to know is that once you become a lawful permanent resident and once you become a green card holder, that does not mean that you cannot be placed into deportation proceedings. There is a misconception out there that once you become a green card holder, doesn't matter what crimes you commit, they can't deport you. That is 100% false. If you are a green card holder, you can still be placed into deportation proceedings. Nobody wants that, but that's just the cold hard facts. So I'm not quite sure I understand your question, but your question made me think of these things that I thought would be helpful for everyone to know. Someone is asking, I filed my VAWA application in April 2025, no receipt notice until now. Should I be worried? I don't know. My office generally doesn't handle VAWA cases. I haven't actually heard colleagues and friends really talk about issues with VAWA receipt notices, but that's a question that's really better asked to attorneys that handle VAWA cases all day, every day. They can give you a much better idea as to whether or not they're seeing, what kind of timing they're seeing when it comes to getting receipt notices. So yeah, I don't actually know that. I can't really give you any kind of insight on that one. Thoughts on the new requirement that's weighted for citizenship applications. I think what you were talking about is for citizenship applications, and this is one of the things I wanted to tell you guys about, so this is a good question. I think what you were asking about is citizenship applications used to be looking at whether or not somebody had, or they used to look at whether someone had good moral character as the absence of the things that would cause them not to have good moral character, right? So for instance, you didn't have a criminal record, you were up to date on your taxes, paying your taxes. If you weren't, you had a payment plan in place with the government. You were taking care of your any children, whether they be in the US or outside of the US. If you had a child support order, you were adhering to that child support order, things like that. So previously they would look at the absence of those things as being good moral character. And now they are looking at not only the absence of things that cause you not to have good moral character, but they're also looking at, well, what do you have that says that you're, that you have good moral character? So we're not going to know how the Immigration Service is really looking at that until they until they get some cases out there where they say, nope, not enough information, or nope, we don't like this information, or here's a request for further evidence, or here's a denial notice, right? So we're kind of not really going to know what they're going to do when the rubber meets the road, so to speak. And it's just such a new policy right now. I haven't heard anything either way on the way that is being processed. So we're just, some of it is just kind of a wait and see. Somebody else has asked, Jay has asked, how does USCIS react to a 3-week unauthorized employment for an F1, which is an international student holder applying for adjustment of status via EB2? Unauthorized employment is never a good thing. So will the officer automatically deny the case? That I don't know. Like, I have no idea. That is a question that I think you could get some really sort of concrete specifics around by having a consultation and really having a conversation so that we could dig into it. But in general, the Immigration Service is probably not going to be happy about that. Will they deny the application? I don't know. That I don't know. There could be ways for you to essentially get that unauthorized work waived. You just kind of have to know how to do that and if it is possible. And that's really going to be a very situation specific scenario. How long is the K visa process? So any processing time depends on the type of case and where the case is. So I always tell folks a good place to start, especially if the case is being processed by USCIS, is to look at the USCIS processing times. If you go to, if you go to the USCIS.gov, their homepage, everything's in a box, right? So if you scroll down to the box that says Manager Case, you click on that second link, which is check processing times. And of course, my computer is a little bit slow, verifying that I'm a human. So if you check that second box, processing times, then you're going to click the form. Then you're going to click the specific category of the form. Then you're going to click the office that currently is adjudicating that case. And then you're going to click Get Processing Time. It's going to spit you out a time. That time is the processing time for roughly 70 to 80% of the cases of the same case types. Now, some cases will process quicker, some cases will process slower, but it gives a fairly good, fairly accurate timing of how long you can expect your case to be processed. So I don't know exactly how long your fiance visa is going to take. But the fiance visa also has two parts to it. So thank you for the rose, Teresa. I appreciate that. So it has two parts to it, which is worth noting. The first part is filed in the U.S. And once that application is done, it's then shipped over to NVC. And then NVC asks you for more documents, and then NVC schedules a K1, or actually, it's three parts, sorry. Then you get scheduled for a K1 non-immigrant visa appointment with the consulate, because the K1 is a non-immigrant. It is not a green card application. So when your loved one then comes in to the US and they come in K1 status, they are not green card holders. They are not lawful permanent residents at that point. They have entered the US in K1 non-immigrant status. After they enter, you can get married, or you should get married within the 90 days. And then after you get married, then you can apply for the adjustment of status, and which once approved will get you the green card. So the K1 is a 3-step process. So, at each step, there is a different kind, there's so the processing times are going to be a little bit different at each step. So just keep that in mind. But yeah, if you go onto the USCIS website, you can see your processing times. What is a common reason why cases stay pending for a long period of time? I don't really know that there is a common reason. There are lots of reasons why cases can stay, remain in processing. There could be a criminal issue that they need to resolve. The background checks may not have come in. Someone may have moved in the middle of their process and the case files had to be changed, had to be sent over to the office that has jurisdiction over the new address. Somebody may have switched jobs in the middle if we're talking an employment-based case. Sometimes the processing times are just long, right? Sometimes the processing times are just long. There's if you're doing an EB2 or an EB3 for employment based, that perm application is taking 12 to 15 months right now. So the processing times are fluid. Like they're not, it's not always going to be the same for every single application. Sometimes people's applications are put into administrative processing. So it really depends on the case type, depends on the office. Some cases take a little bit longer. If an office is completely overwhelmed with casework and they don't have the people to process the cases, right? They don't have the amount of officers it takes to get that, to get cases processed. So then they've got to work to get files transferred to another office that may be processing cases super, super fast and sort of even out the processing times. I mean, there are a ton of reasons. And then there's a slew of just really case-specific reasons why cases can take so long. All that said, what may seem like a long time to you may seem like a walk in the park to me, right? I tell my clients all the time, like, you may think 20 days or 60 days or 90 days is super long and unacceptable. In my world, if I get something back in 90 days, depending on what I've asked for, right? Depending on what I filed, if I get something back in 90 days, I'm super ecstatic, right? So it really depends on a ton of things and can be for a ton of different reasons. Let's see here. What else do we have? Someone's asking, how do they store applications? For some reason, I got asked to send papers I've already submitted. Listen. The immigration process is sometimes really frustrating, right? And it is run and operated by people. People make mistakes. People absolutely make mistakes. Sometimes people are moving a little too fast and they miss something. Happens to me often, right? Sometimes you have submitted evidence, then the Immigration Service comes back and asks for that same evidence. By and large, applications are stored on paper. They are moving to digitize things. This is not some state secret at all. And so over the past few years, we've now been able, they've had they've phased in applications where you could file them online. So with any change, right, with any change comes, just the system's not going to be perfect on day one. And understand that the immigration system is massive. It is massive. There are 5 major service centers in the country, and there are local offices in every state. So when you talk about moving files and moving personnel and moving information from one office to the next, or from DC down to all the other offices, down to the actual person that is adjudicating a case file, that is a massive undertaking. That is not click a button and then everybody has the same information. It is a massive, massive undertaking. So yes, sometimes the Immigration Service will ask for information that you have already sent. It happens. It happens to me, right? It happens to my colleagues. I don't think there's anything nefarious going on. It is a process run by humans. It is a massive logistical undertaking. And so, yeah. My interview was canceled over a year ago. Interviewer was sick. Haven't heard anything since then. I would reach out to the office. I would reach out to USCIS and be like, hey, I haven't had my interview. What would a J1 exchange teacher have to show if they want to do an employment-based visa? Well, they've got to show that they meet the employment-based visa category requirements. So, whether that's EB1, 2, or 3, and any of the subcategories of the employment-based visa, they need to show that they meet those criteria. If you're applying for a green card through an employer, and for some categories by yourself, but still based on employment, there is a preference category. They're very similar to the family-based preference categories. Very, very similar, except they're for employers. So you have to show that you meet those requirements. If you are in J1 status, and this is part of your question, but I'm going to veer off a little bit. If you are in J1 status, it is super, super important that you check your DS 2019 and you check your visa to see if you are subject to the 2-year foreign residency requirement. If you are subject to the 2-year foreign residency requirement, which essentially says after your J1 program is over, you are expected to go home for 2 years and share the knowledge that you received in the US with individuals in your home country. The J1 is a diplomatic tool and exchange program, right? It is not meant to be a gateway to coming to the US and then staying in the US. It was not conceived as that. It was meant to be an exchange of knowledge. And so part of the J1 for many individuals is that they're expected to go home for 2 years. Now, there are waiver provisions. So if you are subject to that 2-year foreign residency requirement and you're required to go home, you cannot adjust your status. You cannot get a green card until you either 1, go home for 2 years, leave the US and go home, or 2, you get a formal waiver that is approved that says that your requirement for that Tier 4 residency has been formally waived. If it is not waived, you cannot change status. You cannot adjust your status and get a green card. So I don't know if you in particular are subject to the Tier 4 residency requirement, but that is something that you definitely want to check on. I had a conversation recently with someone who heard about the Tier 4 residency requirement, wants to attend school here in the US, and wanted to know how to apply for the Tier 4 residency requirement. Well, I start looking at the documents and I was like, well, wait a minute, who told you were subject to the Tier 4 residency requirement? Because all your paperwork says that you're not. And I can't find, there's like a laundry list of skills that the governments have agreed upon. And then certain governments say, if we have someone who's in the US and they're getting a J and they're in, skills A, B, and C, we want them back, right? We want them back for 2 years. But if they're in, skills D, E, and F, we don't care if they stay. And the governments are like, okay, cool, we got a deal. So each country's skills list looks a little bit different, right? So it's very important that you check the skills list. But this individual, oh happy day, was not subject to the skills list at all, was not subject to the Tier 4 residency requirement. So our conversation was very different, very happy, but very different, right? So you really want to make sure that you understand if you are subject to the Tier 4 residency requirement before you get and you sign all the paperwork for a J. But also, if you are here in the US and you have been here for maybe a year or so, you want to check the new skills list, because the skills list recently changed, and it's actually retroactive. So if you were on the previous skills list listed as someone that had to go back for 2 years, but now the new skills list says that you are under the new skills list and you are no longer subject, even though your paperwork says that you are. So if you've been here for a minute in J, you want to make sure that you check that. I had an interview. This is an interesting question. I had an interview and I went with my baby and my husband. I'm assuming this is a family-based green card application. And I was not asked any questions at all. I mean, if you were approved, great, right? Like no questions and you were approved, that would be great. No questions and you weren't approved, I would have some questions, right? But hopefully you were approved. Someone is saying over on YouTube, I was shocked my 751 was approved in 6 months with no interview. That's great. We're seeing some processing times come down. We're seeing some of the processing times come down. So I always love to celebrate a win, even if it had zero to do with my office. So congratulations on your permanent residence. And remember, if you remain married and you are married for 3 years, you can then turn around and apply for U.S. citizenship. What else do we have here? Someone's asking, what does administrative processing mean? So administrative processing is, you're very welcome, Ella. Administrative processing is when either the Immigration Service, I've usually seen it with Department of State, though, with the consulates, but it can happen with USCIS as well. They say that your case is in administrative processing. And generally what I have found that to mean is that they have questions. They have questions about your case. And there are questions that they don't really want to ask you directly. So it could be a criminal background issue. It could be that your name, maybe you have the same name as someone who is known to be a bad actor by the US government, and they need to determine whether or not you are that bad actor or you just happen to be unfortunate and have the same name as that bad actor. It is a what I call a catch-all, where they reserve the right to take more time. Right. So it's not, so I can't say, if someone comes to me and says, oh, I was told my case was in administrative processing. It's not like eureka, I know exactly what's wrong. It's sort of like I need to see everything that was filed so that I can kind of dig through it from the eyes of an adjudicator and say, okay, there's a few things here, or there's one glaring thing here. I think this might be why they need more time. But sometimes you can just reach. In the past, I have just reached out and asked them. I'm like, hey, how you doing? I see the case is in administrative processing. Something you need from us? Happy to work with you, right? And sometimes that works, right? Sometimes it's just the willingness to have a conversation, right? And it is not a conversation on the phone. It is a back and forth with documents. But I always say, if they are talking to you, like if they will talk with me, that's good. Like I'm always excited when they're like, here's a response. I'm like, great, we're having a little dialogue here. Let's see here. What else do we have? It's been 3 months since my husband and I had our interview, but there hasn't been any response. That could be completely normal for the office, and for the visa category, and for the preference category that you might be in. I don't know. I'm not. That doesn't sort of send off immediate warning bells, especially if they didn't tell you at the end of the interview that you were being recommended for approval. So after you have an interview, if the officer doesn't say to you right then and there, I'm recommending you for approval, and even if they do, there are things that have to be done in the background. There are things that have to be done after you leave the office, in order to finalize the application. It used to be when I first started practicing a long time ago. I would go into the local office with my client, and if they were going to approve that person, oftentimes they would approve them right then and there. And then they would put a stamp in their passport right then and there before we left the office that said that they were a green card holder. So the conversation then was very different than the conversation I have with people now. The conversation then was, hopefully we'll get an approval today. And if all things are great, we'll walk out and you will have what we call an I-551 stamp in your passport that will show that you are a lawful permanent resident. And then we should expect to get your card in the mail in X number of weeks, right? Now it is, I haven't seen them put an I-551 stamp in a passport in years. So now what we get is, I am recommending you for approval, right? Because again, all these things have to be done in the background. Or thank you for coming, right? And then they still have to do all these things in the background and they don't give you any indication. Or sometimes I'll get an officer who'll be like, okay, yep, I'm going to send you a notice requesting some of the things that we talked about today. Great. Those are very helpful. I sit there, I take notes, I know what's happening, so I have to-dos, that come before the end of the interviews, right? I'm like, okay, the officer wants this, they want this, they want this. That's fine. And sometimes they just say thank you. And they give you zero indication of whether or not they're looking to approve, whether or not they need more information. So just because you haven't heard anything after an interview doesn't mean that your case isn't being worked on. There are, in fact, things that they have to do after the interview. Even if they tell you that they are recommending your case for approval, there's still things that they have to do on the back end. So again, while I understand that you may think 3 months is a very long time, depending on what's happening in that office, depending on the caseload in that office, if your file goes from the officer's desk to someone else's desk and that someone else is maybe out on medical leave or they are out on vacation, 3 months is like 2 seconds for them, right? So, and I'm not the most patient person. So, sometimes it is a game of hurry up and wait, but the fact that you've had an interview is always a good thing. Like they've given you an opportunity to go in and have a conversation with them. So Frustrating, I know. You want to be done, I know. But we all just have to be like a teeny bit patient when it comes to immigration. My husband has a naturalization interview. Should he bring more evidence than what they have asked for? I don't know, because I don't know the facts of your case. There's sometimes I will recommend that my clients bring certain documents with them, but that is based on the facts of their individual case, and what I think the officer may be looking for or may want to see. But in general, I would start with what they have asked for. Yeah, that's what I would start with. I would, for a naturalization interview, for those of you that don't know, there is an English language test. There is also a civics, or I call it U.S. history. There is also a U.S. history test. So the civics questions, the possible 100 questions, I think it's 150, 100. They're all on the USCIS website. You can go to the USCIS website. It is not a secret. It is not, let me repeat that. The civics questions are not a secret. They are listed boldly on the USCIS website. I send the link to my clients and say, these are the questions you need to be studying. These are the questions that you need to know. So make sure that if you have a naturalization interview, that you know the answers to those civics questions, and they will be testing your ability to read, write, and speak English as well. So just keep that in mind. If I withdraw the I-130, my spouse has the 2-year green card. They filed for VAWA. If I withdraw the I-130, my spouse has the 2-year green card. They filed for VAWA. I filed for divorce. I don't actually understand your question. I'm sorry. Let's see here. Oh, this is a good question. In your opinion, it's always a loaded question. In your opinion, best case to present for Keelantan entry. So a Keelantan entry is when someone enters the U.S., and oftentimes ages ago, especially at like the northern and southern borders, people were just waved in, right? Like people that may like have worked in the U.S. but lived on the other side, either in Mexico or in Canada. So oftentimes they were just waved in, or maybe it was like a big festival and they were coming into the States and like the border was like packed, and so they were just waved in, right? But they weren't officially like stopped, and there wasn't a stamp put in their passport, so that anybody later could say, oh, this person entered on this specific day, right? Or they just don't have evidence that they entered lawfully. And so you can present evidence that this person entered lawfully, right? And so oftentimes people will get affidavits from people that were either in the car with them or crossed with them to say, like what happened. But Keelantan entries are they're difficult, y'all. They are not a slam dunk. They're not a slam dunk at all. So I don't know if I think there is a best case to present for a Keelantan entry. I don't know that I think there is a necessarily like a best case. I think sometimes that's all you may have in your arsenal. But it is always better to have documents. Someone's asking, what's the least amount of time you've heard an I-130 approved? Not too long ago, in a land that seems very, very far away. Sort of right going into COVID, usually we were seeing I-130s, immediate relatives, they were being processed in like 3 to 5 months. I haven't seen that in a while. A colleague of mine just recently said, I think he got something in maybe like 3 months, just for the I-130. But it's been a while since I've seen those types of processing times. But processing times are coming down. What is this? December, January, February, March, April, May, June, July, August. 8 months. Um, I just had a green card approved 8 months. Processing time took 8 months from initial filing to interview to approval. So again, I'll take it. 8 months is like lightning fast. So it really, but that's not, while my case may have taken 8 months, somebody else's case, very similar facts, could take 12 months. So, it depends on type of case, the office the case is being processed in. So it's not a one size fits all. Filing time or processing times for the Immigration Service are flexible and movable, and they're not all going to be the same. They're just not all going to be the same. My husband and I have an interview on Monday. What will they ask? We have all the documents together plus extra. They're going to ask you a lot of things. They're going to ask you about your relationship. Primarily, their job is to make sure that your relationship is real. If they want to know that you all did not enter this marriage for the sole purpose of defrauding the US government and getting engaging in some sort of pay for play where one person pays the other one to get the green card, and that you get over on the US government by getting a green card. That is what they are trying to figure out. They want to know that you all have a real relationship. So for my clients, what I do is I often will do, especially if they're super nervous about the interview, or this is maybe the first immigration interview that they've had to do, I will do a mock interview for them, to give them a sense of the types of questions. And I ask questions, they answer, I give them feedback, so that they feel comfortable with the process from the time they walk into the building until the time that they leave. And then we talk about what they can expect at the end of the interview, the things that should not freak them out that I think would otherwise freak them out without a little bit of guidance. So, if you and your husband want to do a mock interview, you're welcome to. I do mock interviews for folks where I have not prepared the application. My office is more than happy to do that for you. Over on YouTube, someone is asking, my paralegal did not list my traffic citations on my N400 because they did not fall under the guidelines of resulting in arrest over $500 or DUI. Should I say something to the officer? It is the perceived lie that drive officers nuts and cause problems in an application. If your paralegal is working with an attorney, then I would imagine that attorney may be attending your interview with you. So I would have this conversation with your attorney. If you are working with a paralegal who is practicing law and filling out applications and filling them in and not working with an attorney, this is unfortunately a cautionary tale, because now you are left to go into that interview by yourself. So there is always an opportunity during an interview to correct errors in an application. Sometimes there are spelling errors. Sometimes numbers are transposed and written incorrectly. And sometimes boxes aren't checked that should be checked, right? We're all human. We all make mistakes. These things happen. If you think that there are errors in the application, and they deal with any sort of criminal background, I would have a conversation either with the attorney that filed the application. If you're not working with an attorney, then I would have a conversation with an attorney before you go into a citizenship or a green card interview. I would not sort of go in there without knowing what the possible outcomes could be. So that's what I will say on that one. But very exciting that you are super close to citizenship. That is very exciting. How long before a decision is made after submitting your RFE? Unless it is an employment-based premium processing case, the answer to that is it is going to be however long it is going to be. And nobody likes when I say that. And I understand that. The government is not under any requirement to respond to an RFE in a certain amount of time. So processing times will depend on how many cases are on their desk. If they're out on TNG, you are very welcome. How many cases are on their desk? How many? It depends. It completely depends. It depends on the type of case. It depends on what the response was in the RFE. What did it say? What did they ask for? What did it say? So some cases I've had get approved very quickly after submission of the RFE. Other cases take some time, right? So there is no definitive timeline by which the Immigration Service is going to say, once you submit your RFE, we're going to respond to you in 5 days, 10 days, 20 days, 90 days, 60 days. That doesn't exist. That just absolutely doesn't exist. So, that is not what anybody ever wants to hear me say. I understand that. But unfortunately, that's just kind of the reality of it. What else do we have? Let me see. I'll probably do like one more question. For we call this a night because I still looking at my to-do list and I have some more things I want to get done before tomorrow. Let me see here. Some of these I'm not quite sure what y'all are asking. So it's not that I'm ignoring you. I'm just not quite sure what your question is. Ooh, hold on. I should probably plug my phone up before that dies. It's very exciting that they put this in red for me, because otherwise, hold on one second. Okay, much better. Phone is officially charging. No. What else do we have here? Thanks for the follow, guys. I appreciate it. Someone is saying they have lots of proof for their interview. So I'm excited for your interview. So I want to end this on a high note. So I'm super excited for you for your interview. If you've got a lot of evidence of your relationship, I think that is great. So come back and let me know on another live when or how your interview went. I hope it goes well. I like to celebrate wins and approvals, even if I have nothing to do with them, even if my office didn't file or anything. But we like to celebrate wins and approvals over here. So I'm super happy for you guys that you're at the point where you have your interview. So that's how we're going to end tonight. But thanks for joining. I will be back tomorrow around 7 as well, giving you some updates on what's happening in the immigration world, as well as answering some questions. And if you desire to work with myself and the team, click the link in the bio, schedule a consult. All of my clients always start with a consultation. It gives me an opportunity to figure out what's going on with your case, if we are the best firm to help you, and how we can help you, and gives you an opportunity to ask really specific questions about your own case file. And then, and then we move forward and hopefully get you to your goal, whether that's work permit, driver's license, green card, U.S. citizenship, employment sponsorship, sponsoring your own employment-based green card, like all the things. So that is always fun and exciting. So yeah, we'll be back tomorrow answering more questions, and I will see you all tomorrow. It has been fun as always. And I'm Carol Williams with Williams Immigration, former USCIS Adjudications Officer, over doing some policy work out of DC. Now I've got my own firm, helping all of you guys. So this has been fun. I will chat with you tomorrow, and have a good rest of your evening. Bye, everybody.